Hello everyone, welcome back to the Latinx channel. Today we are going to the courtroom. We are going to learn about 12 ways you can give good evidence in court. You know, court cases is a matter of evidence. So your witnesses are going to influence whether or not you win your case or you lose it. There are so many ways that you can be called to be a witness in court. The court can call you. Maybe you're an expert in a particular field, or you work in a government institution, you're a police officer, you're a doctor who does autopsy, or you examine someone in the hospital. The court can call you as an expert to come and give evidence. Someone may call you to come and give evidence in respect of something that you know, something that you've heard, something that you were present to witness in favor of them in court. That's also another way. And then sometimes it may be that you were present when a crime occurred. So let's say you were there and there was a car clash. If you were there, then if somebody got hurt or someone committed a crime and the person needs someone to be a witness, you cannot say, I am choosing not to come and I will not come. No, the court can force you to come and give evidence because it's a criminal matter and someone's liberty is at stake. So you can be called to be a witness in any of the circumstances that I have stated already. So here are 12 things you should know. 12 things that will help you to be a very, very, very good witness in court. Number one is that please give complete evidence. Complete. I don't know if you have a lawyer or you may not have a lawyer, but if you do not have a lawyer, remember that the courts or the judge is not your lawyer. If you have any document to support your case, please give out those documents to the courts. If you have pictures, show it. If it was a text message and you have a text message, please show it. If there's anything that you can prove with receipts, with pictures, or by calling a main witness, please call. If you say that, oh, somebody came to beat me, when they came to beat me, this person and that person was there, call one of those people to come and give the evidence. Don't take it for granted that, oh, I have said it with my mouth and that's okay. If you can call further witnesses, if you can prove with other evidence and you don't do it, your evidence may be half and that may go against you. Now, number two is that say the truth. Some people think that, oh, if you're going to court, then you don't have to say the truth. Tell your lawyer all the truth in the case. If you have a lawyer, if you don't have a lawyer, you as a person should also say the truth. If you don't say the truth and you have a good lawyer on the other side, the truth will come out alive in court. So the thing that you do not tell your lawyer, that other person may also know, or your opponent may know and inform his or her lawyer about it. So your best shot is to tell your lawyer all the truth. There are some things that you may think, oh, it is nothing. Your lawyer may not have drawn his or her attention to it, but you say it out to your lawyer and say, oh, well, this also happened and that also happened. Is it important? Let the lawyer decide that it was not important. Don't say that, oh, I'm not going to tell the lawyer this and I'm not going to tell your lawyer that. If it let your lawyer be surprised in the courtroom, the judge will know that you are not being truthful and the judge will not rely on your evidence. And so please be truthful about your evidence in court. So please take it. The third thing that you have to know is that know the purpose for which you have been called to give evidence. I mean, as you are going to the courtroom, whether you are an expert or whether you're just helping your friend by giving evidence for your friend, please know why you were called. You're not just going to talk. It's not just because you heard it is a land case, it doesn't mean you should go and say everything about the land. No. Sometimes it may be about the land case, but then what is really at stake is maybe a boundary, maybe some portion of the land. Maybe it may be about a child, but what we are concerned about is this child. Which school is best for the child to go to? Oh, who takes care of this child? Maybe that is all the court is looking out for. If you don't know the purpose for which you are going to give the evidence, you may talk and talk and talk and say things you don't even have to say that may hurt the case. So please know the purpose for which you have been called. If you are a doctor and you have been called to give evidence in respect of a matter, you examine the client. Maybe it was a rape case, want to know if there was a penetration. You don't have to go and talk about the rashes on the girl. And no, rashes has nothing to do with rape. unless it has something to do with it. I don't know if you understand me up to this point. Yes, so please know the purpose for which you have been called as a witness so that you can give evidence which is relevant to the case. The fourth thing that you should take note of is that you have to remember your evidence. It is very important. The court wants to know that you are someone who has a good memory and you can rely on your evidence and you can rely on your memory as to what happened in the past. So usually when you go to court, at first, when people are giving evidence in court, they would say everything orally. These days, we don't do that often. We usually write everything on paper. Now, when you go to court, you swear by oath that everything that you have written is the truth. Then the other lawyer or the other opponent will ask you questions. So take note, read over everything that you have written so that you'll not go and say things which are contrary to what you have already written. And try and be consistent. Don't say this tomorrow, then you say another thing. No, we want to know who we can trust. The lawyer was not there, the judge was not there, but we want to know if we can trust you who claim to be there, or you're just saying inconsistent statements. So even if the court will give oral evidence and you say everything from scratch, if they ask you what is your name and you mention Ajwa, and the next moment you are saying your name is Abna, you are giving inconsistent evidence. So please remember what you stated earlier so that you can actually say the truth, because immediately you are caught on one lie, that may make a big difference in your evidence. So please take note of that. The fifth thing you should take note of is that you have to choose a language you are comfortable in or you are comfortable with. So when you go to court, any language that you want to speak, the court will have to make an interpreter available for you. So even if you are in the northern region or you're in Accra and you want to speak Sisala or Dagomba or Ashanti or Frafraha, the court is supposed to get you a Frafraha person who can interpret the language to you in a language that you will understand. So don't go and force yourself and say, because I'm in court, I'm going to speak English. No, it is not done like that. Choose a language you are comfortable with. Everything that is said in the court will be interpreted to you in that language. Then you can answer in the language that you understand. So please take note of that. It is possible for a lawyer to say something in English that you think you understand very well, but you may not understand it. But if that same thing is interpreted to you in English or in your local dialect or something that you really understand, it will make it easier for you to understand. So hey, choose a language that you are comfortable with so that you can give proper evidence from your own understanding and your own dialect. So take note of that one. Hey, the sixth thing you have to understand is that you have to understand the question that is being asked. Please don't set your own questions and answer them. The lawyer is asking you a question. The question is important. The question is supposed to help the court to understand what is happening. So if they ask you a question, please make sure you understand it before you answer. Is it a yes? Is it a no? Is it a no with an explanation? You have to listen attentively so that you can answer. Because if you don't listen and you don't answer directly, it may occur to the court that you are trying to dodge the question, or you are trying hard not to answer the question because you know the answer will not go in your favor. So do everything possible to pay attention to the question that the lawyer is asking you and answer it properly. That's the sixth point. Now, the seventh point is that be mindful of your demeanor in courts. This is so important. We are human beings. You're not supposed to judge you by your appearance or your reactions in court. But the judge is looking at you. As you're answering the questions, do not be angry. Do not show reactions that shows that you don't remember. They ask you a question and then you are scratching your head and you are trying so hard to remember. It means you can't trust your memory. A lawyer is asking you a question and you are so annoyed, you are pissed, you are showing attitude. It helps us to know that, okay, you could have actually shown this attitude like how the other party is talking about. You are being aggressive in court. The court is watching your demeanor. If it is said that you actually beat someone and you actually abuse someone, you attack someone, and you're trying to tell your court that it is not true. You did not do that. And now you're in the courtroom and the lawyer asks you a question and then you're throwing your fists up and down. From that very moment, the judge can even make conclusions in her mind that okay, it's possible. She may not write it in her judgment. She may not state it for you to hear in court, but we are human beings. It may influence her judgment and even the punishment that she may give you. So please take note of that. So the next thing you should be mindful of is that do not be afraid, be confident. I mean, the courtroom looks a bit scary if you have not been there before, but we are all human beings. And there's a judge, a lawyer, we are all human beings. Remember that the lawyer was not there, the judge was not there. We are trying to understand everything from those who were there, your perspective, the perspective of the people who say they were there. You know your facts. If you are saying the truth, there's no point in being afraid or losing your confidence. If you lose your confidence, there's likely for you to miss something very important or very key that the court may be looking out for from you. So be confident, relax, breathe in. If you make a mistake, it will not beat you. If you make a mistake, it will not lash you. Just relax and answer the question as confidently as you can, because you have to convince the judge to believe you. And if you can do that, you have to be confident enough to do that. So please take note of that. Now, hey, this is the next thing. Kindly dress properly. Dress properly. I mean, someone said you have to dress like you're going to church, and I agree with the person. I know these days people dress some way to church, but hey, dress as decent as you can, as formal as you can, as simple and straightforward as you can. Don't dress like you're going for a party. You're going to someone's office. This is the lawyer's, this is the judge's office, and that is very important that you dress well. I mean, we're not supposed to judge people by how they dress and all of that, but hey, in our part of the world and anywhere, people look at you and they can conclude that you're actually a gangster or you're a drug addict. No. If you say you are a very honest person, let us see that in your dressing. If you say we can trust you and that we can trust you on oath, please dress like somebody we can trust. Simple, formal, it doesn't mean that it has to be in suits, but hey, something that we can trust that this person is a very responsible person who knew that he was coming to someone's office and would dress properly. So please take note of that. The next thing you should take note of that, do not be aggressive towards the judge or the lawyer or the police officer who is asking you the questions. Please, all that the police officer or the lawyer on the other side is trying to do is to ask you questions that will help the judge to understand. Now, if they ask you the questions, whether it's a lawyer or a police officer, you are only answering the judge. You're not answering your opponents or the lawyer or the police officer. You are answering the judge. So if they ask you a question and it is no, you say, my lord, no, that is not the case. My lord, it is not true. That is not as respectful as you can be. If you become aggressive towards the police officer or your opponent, you are trying to say that they are asking, excuse me to say, stupid questions, but that is not the case. And so, hey, if anybody is asking you a question in a courtroom, just put it in your mind that the question is from the judge to you. And you're supposed to answer the judge in a way that the judge will understand what is actually happening. Don't be fooled by the energy of the other lawyer or the intimidation from your opponents and what have you, and say things which you don't have to say, because it may go against you. And as I've already said, the judge is watching your demeanor to see who you are. Now, the last thing that you should take note of is that do not assume that the judge knows. No, the judge does not know anything about your case. The judge does not know anything at all. Don't assume that he knows. If you want the judge to know something, tell the judge in evidence, tell the judge by your word of mouth, tell the judge by producing pictures or anything to show. Don't assume that the judge should know that when someone has an accident, their leg will break. No, the judge doesn't know. Even if the judge sees you in court that your leg is broken, and you don't tell the court that your leg is broken or it was broken because of the accident, the judge will presume she did not know. So please, there is no assumption in the courtroom. Tell the judge everything you wanted to know or you want him to know, because that's the only way she can give judgment in your favor. So in case you have gone to court that, oh, this land is for me, I bought it from this family, the states that I bought it from this family, the head of the family is this. Even if you know the judge to be part of the family, don't think that the judge should know who the head of family is. It will go against you. Even if the judge was there when the accident occurred, don't presume the judge will know what happened to the victims. No, tell them expressly. Even if the judge is a woman and the judge has given birth before, don't say, when I gave birth I went through pain, say every pain that you went through, because the judge will not presume for you. Everything you say, the judge is right, and that is how she'll get the evidence that she will rely on to give the judgment. I know you may have questions. There are so many things that I'm sure I've not talked about, but if you have questions, let me know in the comment section. Until we meet again, please have a very, very good time and take care of yourself. Share with your friends, okay? Bye.